Good evening, sir. Welcome to Eyewitness News. Can you bring us up to speed with what the situation is? What is on the table between yourselves, government, and then the CETAG members?
Yeah, the CETAG members gave notice of their strike, alluding to an arbitration award which had been given them and the government had not complied. We brought the attention of the government to comply. Unfortunately, the government did so very late, which was on the 17th of July. But CETAG strike was going to take place from 1st of August. Because finance gave the clearance for the payment of their allowances on the 17th of July, that could not be computed to add on onto their salaries for the July ending. So they gave indication that Ministry of Education said it can only be reflect on their salaries placed for that of August, since the computation of July had already been done. CETAG insists that they want to see the allowances hit their accounts, else they proceed on strike. So it came before the commission. They were invited before the commission, and they failed to attend. They were given a second opportunity to attend. They wrote a letter to the commission that they are unable to attend, so another date is fixed for them, which has been fixed for Wednesday on the 16th. Though their preference was on the 15th, but on the 15th, the commission has another engagement with the Trade Union Congress and the ministry. So it's been fixed for the 16th. Unfortunately, all the trade directives that have been given to them to refrain from proceeding on the strike and then to call off the strike when they proceeded to go on the strike has fallen on deaf ears.
What are these three directives?
That the first was that they should not resort to the strike and to appear before the commission for the matter to be settled. They did not obey, they did not attend upon the commission and proceeded with the strike. We sent a letter to them not once, but twice, that they should call off the strike, and they have failed to call off the strike.
I see. But what really is the practice? So government was unable to fulfill its side of the bargain in terms of the arbitration award. Yes. And so government did later on the 17th, which means it could not reflect as part of their emoluments or salaries for July. But were they shown the proof of this compliance that indeed government is done it, and this is the proof?
Our letter to them included copies of the letter from the Ministry of Finance and Ministry of Education, giving indication of it, even though we were told they were aware already, they were part of meetings. But, we were not part of their meetings. So we made copies and attached to our letter as has been filed with us to them.
Also, notwithstanding this letter instructing the controller to make good this award, they still went ahead and
they still went ahead to declare the strike.
What could account for this? Is it that maybe based on past experience, they did not trust that government will indeed follow through with the letter it gave to the controller and accountant general, so that at the end of the month they will see their money?
I am unable to assign reasons to their action.
And
will be the best.
Yes, and so based on the letter you saw, the 17th July letter you saw, you told them not to resort to the strike, but appear before you, and then they still went ahead and undertook the strike. But what does that make the strike? Does it make it legal because you were informed?
Yes. No, it is. No, you see, the reason for giving notice of the strike is to enable the National Labour Commission or any other body, by way of mediation or arbitration, to intervene to see whether they can find a solution to the problem at stake, because the strike is often the last resort. So by notice to us, we took steps to bring in the government, that is through the Ministry of Education, to perform its part of the bargain. And that is where we were able to get government to, accede to the performance of the honoring the arbitration award. You understand me? So if the government has agreed, and for that matter, letters from the Ministry of Finance have been issued to that effect for the payment of what is due you, per the conditions of service agreed on, was there really an essence of going on strike? And if you say you want to wait, assuming they were even issued checks and it went to the bank, it will not hit your account the same day. So it's simply going to take a minimum of 3 days. So they had all the assurances, but then so went ahead. Anyway, they may have other reasons which they are yet to say. So I don't think the strike is lawful. No, it is not. Because the commission is the only body that is empowered to declare the legality or otherwise of a strike. And the commission has told you, don't go, and you went. And it said, now come back, stop what you are saying, I won't stop. Stop, and you are saying you won't stop. Defiling the orders or directives of the commission itself is an unlawful act.
I see. So given the unlawfulness of this strike or this act, what powers does the commission have to make right the wrongs?
Yeah, the commission will have to resort to the court to compel them to go back to the classroom if they still proceed on the strike. And then their employers will also have the right to punish them for proceeding on this illegal strike.
How would the employer punish them? Because the employer is in default. So how does an employer who is in default of some payment for which reason the workers are on strike punish them?
The default for which the government is in or the employer is in comes with its own sanctions. Two wrongs do not make a right. The fact that the employer is in default or was in default does not mean that you can also do anything. Two wrongs do not make a right.
But what sanctions did the employer attract in delaying to follow through the arbitration award the NLC made?
The employer could be made to pay interest on the sums that it has not paid over the years.
But is that the case? Is that the case in this particular one?
At the moment, not. But if they really had applied, if they apply, when you go to court, then you apply that somebody owes you. You must apply for interest, cost, and other things. It's based on the application that you put before the commission. If they have brought it to the notice of the commission, they haven't given us the award, the employer has still failed to pay. And within the period, we are requesting for interest on this. We have done it several times for different organizations and different persons where awards and other things are made and paid with interest. So it was an opportunity open to them.
I see.
Except that they have failed to avail themselves to their rights or what is due them, but rather resorting to an unlawful act.
I see. You mentioned that the NLC could go to court to force them back to the classrooms. Is it a viable option you are considering, given that you say on the 16th, which is a few days away, you have a meeting with them?
Consider that. We have just tomorrow and the next. So if you go and file an application in court, before they are served, the court will hear and make the orders. That's going to take no less than 1 week. So it is not an option the commission is considering for now. Because at least for now, even though this thing could not reflect last month, this month today is on the 14th. It's been prepared already, and I'm sure it's going to be part of their salaries for this month. So there is no need.
But I do not know how it works. But couldn't it have been paid midstream so that it comes as and when it's ready?
That is for the controller to tell. But what the controller to Ministry of Education told the commission was that they had finished with the computation of July salaries, and that they were going to add on to their August salaries. But whether there was a viable option or not, that sitting here at the commission, I will not know.
I see. You also mentioned that the employer could punish them by withdrawing their salaries for the period. Is it an option you think the employer will exercise this time around?
Well, I don't know. It is an option available to the employer that when people engage in an illegal salary strike, you can withhold their salary. And the leaders of this thing could also be made to bear the cost of any damage or losses arising from the unlawful strike that their members engage in, right? And that people who also lose their appointment without notice.
I see, but just to be clear, in your interaction with the employer, you have not picked up any such information that the employer will want to.
You have not interacted with the employer without the CETAG being there, except at the commission meetings where they were called and they refused to attend. But as a commission, we don't have any private interaction, or what do you call it, ex officio or
ex party.
Ex party. This thing with them, no.
Very well.
At every point in time, the two parties are invited before the commission. If there is an interaction with one party, it means the other party has due notice but has failed to attend without reason.
I see. Thank you so much, Executive Secretary of the NLC, Mr. Ofosu Asamoah, for speaking to us on this matter. Thanks so much, and we wish you the very best in your meeting with the feuding parties on Wednesday.